At the onset, I'll tell you this is not going to be a lecture. I would prefer that it's an interactive session because I completely believe in active discourse and debate and discussion. Basically, we are trying to build a conversation around this area. I'll start with a few clippings. So I'm stepping away from the mic, okay? I'm audible, right? I'm audible. Basic things. So what usually happens in areas that are so specific and focused such as this is that you directly go into the topic without looking at the fundamentals, and most often these fundamentals are the foundation or laying stones of how you get clarity in areas such as this. So I thought I'll start with a few video clippings. These are movies that are not directly involved with reproductive justice, but it has to do with mental disability. So through these videos, we'll try and define what is mental disability. We will try and see how they are marginalized. And through their marginalization, we'll look at how women and women with mental disabilities are treated with respect to reproductive rights. So it's a multi-layered, hierarchical system of marginalization, which I'm trying to get through with respect to trying to dilute it when you try to understand these various concepts. Just before showing the clippings, I just want to understand your idea of state interest and individual interest with respect to reproductive rights. What are reproductive rights? Please talk. This is going to be a conversation. What according to you are reproductive rights? It could be right, wrong, anything. Reproductive rights in India.
Like to have children, not have children.
So it's basically to do with reproduction. And when you say reproduction, the key legal term that usually stems up in your mind is abortion. So when you talk about abortion, abortion rights are generally, it takes away the majority of the sphere with respect to reproductive rights. What about abortion is state interest? ഞാൻ ചോദിക്കുന്നത് very simple ആയിട്ട് ഞാൻ ഒന്നുകൂടി ചോദിക്കാം. When you talk about abortion rights as individual rights of a woman, അതിൽ state interest എവിടെയാണ് വരുന്നത്? When does state interest seep in? What is state interest with respect to abortion? Did you understand what I'm trying to say?
Manpower can be an interest.
Manpower. How so?
Every citizen is a welfare of the child. Every citizen is a resource of the state. That could be one.
I still didn't get through.
Every citizen is.
Okay, so basically you're looking at a person's life as being important because to build up the population of citizenship or whatever.
See, for a state to perform, it
Yeah.
needs resources.
Yeah.
It has to be utilized properly.
So you're saying this child's life is also a resource.
that could be a.
Exactly. So when you talk about state interest, we're talking about right to life of the fetus. Or it's not you don't need to classify it as manpower or child welfare. You can put it as simply as saying the right to life of the fetus. So on one side, you are talking about a woman's autonomy. So you have the right to choose, you have the right of consent, you have the right to bodily autonomy on one side, which also includes the right to life of the woman. And on the other side, we are talking about the right to life of the fetus or the unborn child, whatever you want to term it. Again, coming back to the roots of the question, why is the state worried about the right to life of the fetus vis-a-vis the right to life of choice of a woman? So we are talking about an unborn child and an adult or a person outside the womb, and that person's choice. How are you going to balance this? This is the typical argument for any abortion law. Which is the most recent law or case that came up in the US that has taken away practically all abortion rights? Do you remember the case? Which year? Dobbs, which year? 2022. Yes. Fag end of 2022. So we will be discussing all of these concepts through this process, okay? So this is just for conceptual clarity. So we'll start off with the videos. Have you seen Perenbar?
Yes.
Mammootty movie? So this is basically, so the scene that I'm going to show right now is Mammootty has a teenage daughter who is mentally disabled. And he starts seeing changes in her. So when she watches movies, especially Surya movies, who's her favorite actor, she starts showing affection towards this person on screen, and then Mammootty realizes that she's having these sexual urgencies or sexual urges, which she's not able to express properly. So what does he do as a father? So the next scene that I'm going to show is basically, you can see the scene and then probably we'll discuss. Okay, so this is a transgender who Mammootty befriends just to understand how they work and all of that, and he actually wanted access to go to a prostitute. And the next thing that you see is he is actually taking her help to reach a prostitute, and he's going to the prostitute in search of male prostitutes so that his daughter can have her sexual desires fulfilled by that prostitute. uh, Throwing light into social stigma around the sexuality and sexual expression of mentally disabled or mentally challenged humans. And generally, not only mentally, just physical disability. So this is one clipping that I want to show. Has anyone watched this next one, Margarita with a Straw? It has won several awards, and Kalki is acting in it. So just to give you a brief of this, she is a woman with cerebral palsy. So so cerebral palsy, I hope you know. So your entire motor organs or organs do not work, but you have a mind, you have a brain, you have an intellect that works, and at the same time you have all emotions also inbuilt in you. It's just that you are not able to move. So that's physical disability that you're talking about in this case. So again, here she through this is a beautiful movie. Her mother is Revati, and this is where she explores her sexuality again. So she's exploring her sexuality, both men and women. And this is just a trailer. You can just have a quick clipping. There are 3 more other clippings. If you want me, if you want me to, I can take you through that. So there is one movie that is called Come As You Are. So this is basically a group of boys. Boys as in they're in their late 20s, early 30s. They're all, one of them is physically handicapped, the other person is having a mental retardation, he's in the autism spectrum. So all of the 3 boys get together and they decide that they're going on a trip, and they're going to, they're going to go to this special needs brothel. So that is their aim. So it's basically they travel and how they get there and all of that. Again, that is also looking at the aspect of choice and aspect of sexual desires in disabled people. The other 2, Peanut Butter Falcon and Me Before You. Me Before You, I think it's a very famous movie. It's a very commercial movie. That is a person who met with an accident. He was a fully abled person. He suddenly met with an accident. From neck down, he becomes paralyzed. So a caretaker comes to look after him, and then finally they have a chemistry, but he decides that he is going to die. So he goes to which is one country where euthanasia is legal. So he goes there and he administers euthanasia and he dies. So that's the story. And the other one, Peanut Butter Falcon, again that is a very beautiful movie. It's won a lot of international awards. This is where a person with Down syndrome, and I think I'll just show you that, it's very beautiful. A person with Down syndrome, so this is an actual person with Down syndrome who's acting in the movie. He wants to become a boxer. So there is a caretaker in his house who's looking after him and his aged father. What he does is he runs away. And he meets a person who's traveling, who's a nomad sort of person who's traveling. They strike a very good friendship, and this person and the person with Down syndrome basically travel, and then finally he enters boxing. So the reason why I tried to showcase all of this is because generally, like Vismi ma'am was saying, there is this concept of ableism. We only see, wherever we look at, like whatever field or industry that you look at, you only see people who are able, as defined legally or as defined personally and morally, in those fields. These are certain movies in, or these are areas in popular culture where you can see that differently able people are taking the mainstream and doing things that people otherwise also do. So this is just to basically give you an insight that differently able people or special needs people do have authority or agency to give consent. They do have desires, they do have choices, yet the concept of legal paternalism. This is again, I think it is there in your concept note also. The concept of legal paternalism takes over. So, how are we going to, as law students or legal practitioners, how are we going to compartmentalize each of these sections and then finally unify it so that everything is balanced? So, when we talk about when we started the conversation about state interest and individual rights with respect to abortion, this is going to be more layered. Layered in the sense, we are talking about state interest in the right to life of the fetus. We are talking about autonomy also with respect to the woman, the right to choose whatever she wants in life with respect to her body. That is also there. We are going to add one more layer when it comes to this marginalized group, which is disabled people, which is any guesses? Like, so you have, I'll just show you, I'll just take the images. If at all at any point of time I'm not coming across, please do let me know. I have this tendency to like just go on. So when you look at, so this is what I was actually talking about. Is this visible? Yeah. So we're talking about two aspects in the same spectrum of a single right. If you talk about Article 21, on one side we are talking about the right to life of the woman, her privacy, her bodily autonomy, her right to choose. On the other side we are talking about state interest. When can the state encroach on your right to choose by making reasonable legislations, and when is it justified? That is the golden triangle rule. So this justification comes from the right to life of the fetus. The state interest is in the protection of the right to life of the fetus. Now I'll ask you another question. Why is the state so interested in protecting the right to life of the fetus over the right to personal autonomy of the woman? I understand that he said manpower or resources. What would be the state interest with respect to fetus? Fetus is unborn, not even come out of the womb. Why is the state so interested in protecting that life over the right to choice of a person who's already there, who can make decisions? What could be the logic in that?
The concept of legal paternalism.
What is legal paternalism?
State is another manifestation of the patriarchy. We could say it like that.
That is one argument, yes. So, the whole idea of reproductive rights, rather reproductive justice. So there's a difference between reproductive rights and reproductive justice. Reproductive rights is basically your political right saying that, see, you have the right to abortion. It is given according to the constitution and under this right, or it is there within the permits of the constitution. Reproductive justice is completely different. It's basically the implementation level of the reproductive rights. Is it accessible to you? That is a question of reproductive justice. In reproductive rights, you ask the question, do you have the right? If it is yes, okay, fine, you have the right to abortion. But is that right accessible to you is a question of reproductive justice. Now, accessibility depends on a lot of factors. One is class. This is how the concept of reproductive justice came out to be. There was this, have you heard of this? The entire term of reproductive justice was coined by black women in America during the 1940s, 50s. So this, what usually happened during that time is abortion rights were available, but it was available only according to the class because it was extremely expensive. One. Two, it was available easily to white women over black women. Three, black women needed it more because of their economic status. So if you look at family planning, if you look at the number of children, I'm talking about that point of time, number of children in a family, it all had to do with lack of awareness and economic, I mean, basically the economic and social status of that family as well. So this whole idea of reproductive justice was something that was brought out by women of a particular community, basically the black women. Now they have something called Sisterhood Campaign of Reproductive Justice, where it's basically a campaign that is run by women of color for reproductive justice. So that's why I said this is layered. It's not just when you talk about women's right on one side and when you talk about legal paternalism that she was pointing out on the other side. Again, women's right on the other side is still layered. It is layered by class, it is layered by ableism, it is layered by your economic and social status. In India, it is even layered by caste. Okay, so I'll give you another example. Do you know the history behind the MTP Act? What is the MTP Act? When did it come out? Medical Termination of Pregnancy year?
71.
Yes, 1971. What was the reason behind it? Okay, before that, do you think it's a progressive legislation? Any idea the parameters, Millie? Any idea the parameters? I'm just asking you because you're doing this area. When is abortion legal in India? Till when?
24 weeks with two
Yes.
specialists, otherwise 20.
Yes. So 20. So we have a limit of 24 weeks. Actually, even after 24 weeks, there have been a few instances where you can go to the High Court and get an order. Okay, but that's very rare. We have a legal permit till 24 weeks, and till 20 weeks you can easily go, but after 24 weeks it's a little more difficult to get an abortion. Is there any country, do you have any idea about any other country in the world that permits abortion till 24 weeks? Let's talk about European countries. Yes.
Ma'am, you will address what was government's interest in protecting the life of people?
I will come back to it. So I'm trying to gather all the information, put it in a bucket and then go back. So I'll come back to it. I'll circle around. Thank you for reminding me. I'll definitely circle around. Do you know any other country? Let's talk about European countries. Germany and Ireland. Irish law, any idea? When you see, generally the perception with respect to European countries or US is that they're very liberal countries, very liberal with respect to such laws or such ideologies. But if you look at especially Ireland in their constitution does not or abolishes abortion. It is only very recently with an amendment to Article, I think Section 34, that they brought in abortion under two very specific circumstances. Abortion as a right in Ireland is available only if it is threatening to the life of the mother or her health. Right to life of the mother or her health. Those are the only two conditions in which abortion is allowed. Otherwise, it is a complete ban on abortion. Germany is similar. Look at US. Again, I'm just circling back. We went to Dobbs case. It started from Roe versus Wade. Roe versus Wade was a very progressive decision. You had the 3 trimester system. Then came the Planning Commission versus Casey, which is an undue burden test. So from Roe versus Wade, we went to undue burden test. Undue burden is where the court said that if and unless abortion is possible if it causes an undue burden on the woman. So look at the woman-centric approach that the court took. If it causes an undue burden on the health or whatever of the woman, abortion is possible. So it moved away from trimester test to undue burden. Then finally we have Dobbs, which overruled the entire thing and said abortion is not possible. So the question is very simple. Why are women's rights always a question or debatable on one side, whereas when you come to right of the fetus, there is a blanket, okay, the fetus needs a right to life. I'm being a devil's advocate, okay, this is not my personal opinion, I'm just trying to get you to speak. So, yeah.
Catholics, they don't allow it for them, it's a sin.
So are you saying that we are influenced by the Victorian morality?
Catholic faith. For them, it's a sin. So they don't allow it. Being conservative.
Yes, okay. So I will try and connect these two aspects. So abortion became a crime under the IPC for the first time in India. Under 1860 IPC, abortion became a crime. Again, I'll connect this and by the history behind the MTP Act. It came in the 1970s. Why? Okay, with respect to India's politics in the 1970s, 60s, 70s, late 70s, till late 70s, what is the key feature that just suddenly comes to your mind?
Vasectomy is enforced.
Exactly. So it was a period of emergency. It was a period of population control. So there were forced sterilization movements. That was basically the campaign was run by Sanjay Gandhi, and he went all over India sterilizing forced vasectomy. And the places where these vasectomies took place also you had to see. There's a documentary on it. If you're interested, I can give you a link to it. It is very unhygienic, and these people also, they didn't know what they're getting into. So the slogan that was given out was that, and many people, many families were paid to get vasectomies. And so this happened in the 1970s. So it is this very set of people that sat and debated about the MTP Act. So MTP Act, unlike what a lot of people think, though practically it turned out to be beneficial, the intention behind it was not to promote women's rights. It was not a feministic approach to give equality to women or to give bodily choices to women or to allow them to engage in public discourse by utilizing or enforcing their right to choice. The idea was family planning. Now, how are these two connected? If you make abortion, so very, very, very smart move, I would still say, this is my personal opinion, I would still say, though I do not agree with her on any count, I would still say she is probably one of the smartest politicians that we have till date, Indira Gandhi. I mean, smart in the sense, she was very, being political, she was very smart with respect to how well she placed ideologies such as this. So you had family planning, they wanted to reduce the population of India, there was a mass forced sterilization move. What better way than give access to women to abort? Easy abortion, economical abortion, legal abortion, and also accessible to all women of all classes and castes. This was the idea behind MTP, and this is not my personal opinion, this is actual research. I can give you links to the research papers by the end of this. So when you talk about MTP as being like women-centric and giving rights to women, think backward. What was the intention, actual intention of MTP? Now coming to the current legal system. Your question was with respect to?
No, what was the government's interest in protecting the life of the fetus?
I'll circle back, yes. I need to cover a few more things. That comes with women with disabilities looking at reproductive rights. So already women, as you can see politically, so it's not even supposed to be a political debate. It's supposed to be as of a human right. But yet, women's bodies are always called into question with respect to politics. I'll give you another example. No, but that's going to be controversial. You can keep it, right? So this is the multiple layers that you see with respect. You have state interest, you have women's right to choose, and then you have other degrees under women's right to choose. Only certain women have the right to choose, basically. If you are disabled, your right to choose is almost negligent, is almost absent. If you are from a particular class again or a particular social background, your right to choose with respect to abortion practically is still negligent. So I will give you an example. This was a drive that happened in 2014, as late as 2014, in one of the districts in Bihar, if I'm not wrong. So there were clinics that were opened up, again forced sterilization. What they would do is they would give out money to Dalit women. And there were around 83. So how you do sterilization for women is you tie up the tube. That is one way of mechanism of doing sterilization. So there were around 83. I forgot what the surgery is called. I think tubectomy. But that is. Are you sure it is tubectomy? Okay, then tubectomy. So there were around 83 tubectomies done, out of which around 20 people died. Out of 83, 20 is a huge number. And this was because lack of medical training, proper medical equipments, and the doctors, again, these were all just MBBS graduates who were called by the government and they went on this drive. And this was as recent as 2014. So you should understand that though we have the MTP legislation all in paper, such drives are still being conducted by the government. So yeah, so that is one. So I'm just talking about the layered issues with respect to rights. Okay. Now, when we come to the layered aspect, the most important feature with respect to women's rights is the right to consent. So this is where conceptually there's a lot of issues. So why do you think that women with disabilities, and we are talking about legal paternalism also, women with disabilities are seen differently than able-bodied women with respect to reproductive rights? The reason is their ability to give consent. So that is why, this is why I showed you the video clips, okay? Just so that you are aware that they can understand, they have feelings, their consent is not necessarily intertwined with their mental disability. And this is exactly what the UN Convention on Rights of Disabled People talks about. Under Article 12, they say that UNCRPD, that is Convention on the Rights of Persons with Disability. So under this convention, under Article 12, right to make a family and reproductive rights are mentioned. So there is a very interesting, before going on to that, how this works is, if there is a particular provision in United Nations conventions, generally general comments are brought out by the General Assembly. So these general comments basically try and elaborate on what was the intention of the convention makers when this provision was made. For example, under the, what is the Civil and Political Rights Convention called? ICCPR. So under Article 19, Article 19 is freedom of speech in ICCPR also. Under Article 19, there are many comments, okay? And if, especially, very interesting to go through that. If you look at General Comment 36, it specifically says that freedom of speech cases, the state should not interfere. In the sense, if the state is making a law restricting your right to free speech, that law should be so good in the sense the burden of proof is on the state to show that this law is absolutely necessary for restricting speech. Okay, so this is the kind of, I was just trying to throw insight on what these general comments mean. They basically elaborate areas where the main part of the legislation or convention is silent. So Article 12 talks about reproductive right. General Comment 1 talks about the difference between legal consent and mental consent. So this is very beautifully given. I don't know how far the case laws or the legal practitioners know about this. Legal consent is the agency, or it's basically your understanding or your capability to understand rights. So if I say that, imagine I'm a mentally disabled person who's pregnant, okay, and if questions are asked to me, do you know your reproductive rights? If I say yes, I know I have the right to abortion, that is legal consent. That means I know or I understand what my rights are, and the responsibilities that come along with those rights. But mental consent is considered different. Mental consent is basically, it cannot be decided by your intellect or the level of your IQ. It is circumstantial and it depends on case to case basis, and it depends on how you react to certain circumstances. You have seen that movie, Deva Tirumagal, Vikram's movie. The English, it was copied from an English version called I Am Sam. So this is basically where a person with very low IQ, so he's on a spectrum of autism and borderline mental retardation. Person with very low IQ has a biological daughter. The mother leaves the daughter with this man and goes away. So the entire story runs around how this daughter grows up to be more intelligent than him, and how he's struggling to give her what she needs. Finally, in the English movie, social welfare workers come and take the daughter away, and it's heartbreaking to see, because it's not that he doesn't understand, it's not that he doesn't express love, it's not that he's not taking care of her, and he even understands that he is incapable of looking after her after a certain point of time. So, but then, so I was just trying to elaborate on how mental disability doesn't usually coincide with your idea of understanding. Legal consent is different, mental consent is different. This is what the general comment to this particular provision tried to bring out. Bismi ma'am mentioned this case, Suchitra Srivastava, 2009 decision. So what had happened in this case is, it's an orphan girl. She was around I think she was 24 years old, who was having mental retardation, and she was 19 weeks pregnant. So the state authorities where she was living found out that she was 19 weeks pregnant only during that time. So there was a petition made to the High Court for abortion. So the question, and the interesting part was, she didn't want to abort, she wanted the child. So the question was whether the state will recognize her right to choice, or whether they will look at right to life of the fetus. Here the choice being for the right to life of the fetus. Okay, so this was a very interesting, like jurisprudentially, it is considered to be one of the biggest or most applauded cases all over the world. The Indian judiciary gave out a very beautiful decision, jurisprudentially. But the reasons behind it, again, when you look at it, I'll come to it. Okay. So what the court said is that they again distinguish between legal consent and moral consent, and they said that when she says that she wants to move ahead with the pregnancy, that needs to be looked at only as mental consent. That doesn't need to coincide with legal consent. She doesn't need to have legal consent in this case. And the court used the best interest principle. So on the one side, there was parents patriae principle, whether the state can step in and look at the right of the right to life of the fetus, and maybe go in or do. So what the state wanted abortion, because the state will have to look after the child if the child is born. So it was the other way around. The woman wanted the child, the state wanted abortion. So the question was whether the state can step in, take parents patriae and say that this woman cannot look after herself and the child needs to be aborted, or whether the state should provide and give individual interest more importance. The court finally adopted best interest of the woman principle and allowed the pregnancy to fall through. So this was considered to be one of the biggest breakthroughs with respect to abortion laws in India. But the problem here is, again, if you look at this person was 19 weeks pregnant. It would have been harmful for her if this court had allowed abortion. Harmful in the sense, see, her body is basically changing. There's a lot of hormonal changes that goes through internally with respect to a woman's body through pregnancy. It would do her more harm than good if abortion was allowed. So at the outset, it looks like a very good very good decision, but this was the real reasoning behind it. And again, this was not a feministic approach. What I'm trying to say is, whether it be the MPT Act or whether it be such a beautiful decision, it was not because they gave importance to the right of the woman. It was not a feministic approach. It was more or less political, and in this case a health issue. Question. I thought I'll give you a proposition and then probably you can try and answer the proposition. I'll give the questions by the end of the illustrative example. After reading, just let me know. You can read it out loud also for those who cannot see. A 26-year-old woman with intellectual disability, okay, that is WID, is brought to the obstetrician by her parents for medical termination of her pregnancy. On examination, the woman is found to be 19 weeks pregnant with possible low intelligence and she is unaware of her pregnancy status. The obstetrician seeks a psychiatrist's opinion regarding her ability to consent to the MTP. A detailed assessment of the psychiatrist reveals that she has a moderate intellectual disability. She needs assistance in her activities of daily life. On inquiring about her pregnancy, she reports that she likes babies and can play with them. She is unable to reveal details about the father of the baby. She expresses happiness after being told she is pregnant. However, she cannot comprehend the roles and responsibilities of being a mother. The parents state that they want her to undergo a hysterectomy and MTP as it is difficult for them to provide care during pregnancy and protect their daughters from unwanted future pregnancy. She has a poor understanding of self-care, menstruation and sexual knowledge. How would you decide this case if it came up before you as a court? If you're sitting as a single bench. You understood the facts, no? What would you decide? There's no right and wrong here, you can decide anything you want. But I'm looking at your logical reasoning behind the decision. So the legal questions that come are this. How do you assess capacity? Who will be responsible? If the court allows, who will be responsible for taking care of the child? This is where you again start questioning legal paternalism. Simply you say legal paternalism, the state is, trying to be a parent or state is trying to get into the shoes of a disabled woman and trying to speak for her when she herself can make her own choice and all of that. But look at this particular circumstance. Who has to take care of the child?
Why there is no option for a foster care in such cases?
Exactly. So this is what I was actually waiting for. When you say, I'll circle back to you, right to life of the fetus. If the state calls that a state interest, that state should be a progressive state. The state should be actively involved and look at right to life as a positive right rather than a negative right. I hope you know the difference between positive right and negative rights. The state should be like the South African state. In South Africa or the South African constitution, what the state has to play an active role to ensure that every individual's right is protected. Similarly, we should have the mechanism, we should have the economic stability, the infrastructure to support state interest in the right to life of the fetus. The state should, like she was rightfully pointing out, get care systems or care houses where such children can be looked after. Do you remember have you seen the movie Magalkai, where Shobana is mentally retarded and she has a baby? That song is there, no? Chanjadi Adi, that movie. So she's institutionalized, she has a baby there who is normal. And the baby is living around people who are mentally retarded. Does the state have the infrastructure to look after and care for such children? Only then will Suchitra Srivastava be actually beneficial. Otherwise, it will be just in paper and in that particular case, in that particular instance, where the parents, in this case, if the state says, okay, the parents will have to look after. The woman is unable to look after herself, she doesn't even know her needs. So this is one side of the coin, you can argue the other side also. Anybody for the other side of the argument? Again, like the next question is about legal paternalism. Can somebody step into the shoes of the woman and give consent on her behalf? So these are questions that, according to law, you can answer, but only a medical practitioner or a psychiatrist can give it to you in paper whether that woman is actually capable of or not. Okay. So I'll just take you through the I think everybody's getting bored. I'll finish off the legal provisions so that you have an idea of what we are talking about, and then we'll probably wind up. Yeah, so these are the legal provisions, constitution. So, if you look at the Rights of Persons with Disabilities Act, it's very important that you go through these sections. I'm not reading it out, but these are very, very important sections, especially if you look at section 10 clause 2. No person with disability shall be subject to any medical procedure which leads to infertility without his or her free and informed consent. So, no infertility procedures can take place without informed consent. Now, the question of what is informed consent, we have certain guidelines given to medical practitioners, but that's about it. So, informed consent is a very different area. I'm not stepping into that because there's a lot to speak about it. Okay. So, again, if you look at section 13. Any person providing support to the person with disability shall not exercise undue influence and shall respect his or her autonomy, dignity and privacy. So a lot of importance is given to a woman, irrespective of the gender, irrespective of the kind of disability, a lot of importance is given under this legislation to a person with disability with respect to the person's choice and consent. Okay, this is how the letter of law is. But how can we practically make it happen in a country like India is a question of implementation. Yes.
This WE Act section 92A talks about insult.
Yes.
Certain person is insulted, he is punishable. How is it executed? Is there any provisions in the WE Act where this law is
About insult?
Yeah, if a disabled person is insulted in public view,
I understand your question. I'll come. So the thing is, I have not gone with respect to insult specifically. There is a provision under 92 which directly relates to abortion. That I've gone through because that is my.
it's not enforceable.
Exactly. So if you look at the majority of the provisions under the Act, it's not enforceable. How are you going to understand from the disabled person is the victim, right? So the victim should be giving key evidence. How are you going to understand from that person that this has happened or not happened? And this is the premise for any activity relating to a disabled person. For example, I showed you all the video clippings, sexual desire. Let's talk about sexual assault or rape cases, where consent or will of the person involved, the woman involved is very important. How are you going to prove or disprove consent in case of sexual assault? So we go back to the question of whether that woman is capable of making an informed decision with respect to sexual activities. Does she know what is going to happen during sex, after sex, and that leads to pregnancy? Did she know about contraceptions? Did she know about what is going to happen after a child is born? These are questions that are always left answered because even though you have such a beneficial legislation such as this. So that is the irony of this legislation or these provisions. Like he was rightfully pointing out, that is with respect to insult, which I didn't go through, but you have section 92, a particular part which says, whoever performs, conducts or directs any medical procedure to be performed on a woman with disability which leads or is likely to lead to termination of pregnancy without their consent. So if a medical practitioner goes without that person's consent and does termination of pregnancy, this is a penal offence. 6 months, I think 6 months? Yeah, not less than 6 months, but shall extend to 5 years. So this is a mandatory minimum provision.
That's what I'm talking. It's a penal provision. There are punishments.
Yes.
But RPW Act itself is not considered as a penal provision. Because where do you approach?
Are you talking about redressal forum?
Redressal or in 84, section 84 is about you can go to the sessions court or criminal cases.
Yes.
You go to High Court, they accept it only as WPCs, civil. They don't look into the criminal aspect.
So no, so there's a difference. This is similar. What I understand from my limited reading is that this is very similar to domestic violence provision, Prevention of Domestic Violence Act. That is considered to be a civil remedy. I think this is also considered to be a civil remedy.
I'm a disabled person, that's what
Yes, sir, I understand. That's also considered to be a civil remedy, but with penal provisions. So, for example, under the Domestic Violence Act, the application has to be made to the magistrate. Though the entire legislation, the scheme of the legislation and the statement of objects and reasons also signify that it is a civil remedy. If you want a penal remedy, go to 498A. Currently, I don't know which provision under the BNS. So 498A IPC.
Why don't they go under 92A of the Reproductive Act, approach the police or approach the magistrate?
I am not very sure of the implications of that. I don't think the police knows about it.
You have to FIR registered
Under this legislation. Okay, so then I am not aware of it.
But the problem is, I cannot approach the High Court in this context because I'm limited at the Sessions Court.
So I think the biggest problem here is you do not have a complementary IPC or BNS provision.
It's not my idea, it's my understanding is High Court doesn't have an idea about this RPW Act because their rosters are prepared for WPC in the RPW Act. There are no criminals, there is no WP criminal under the High Court.
Are you talking about the perpetrators? Okay, so yeah, that's exactly what I was trying to say. So when you look at such legislations, even same principle applies for the Domestic Violence Act also. You can only approach the magistrate. You cannot go beyond that. And if at all a provision comes, it is not for a penal provision. It is for protection or some protection orders or something that will go to the family court. Similar with this also. This is, you can only approach a sessions court at the most. High Court, but sir, I still don't understand. High Court if you can approach the Sessions Court, under what regard do you want to go to the High Court?
I have to file an appeal against the Sessions Court judgment.
That you can otherwise also go.
Where?
A criminal appeal, it will lie, normal appeal.
This is, like here, 2C is controlled by Justice Shobhana Maker. Justice handles the WTC matters of the RPW. And there is an appellate court by Justice Devan Ramendra. They take the appellate cases against the WPC matters. It's not criminal provisions. You go there, they say we don't have. You go to the sessions, I'm saying.
Okay, I am not aware of this. I have not done research in that detail. So I think you should ask the legal practitioner. I think I am limited as an academician. Dada, he's a practitioner.
We both are practicing.
So we can, this came from her idea of foster homes, where I said that unless and until we do not have the capability of providing infrastructure, what is the state interest in protecting the right to life of the fetus if the woman doesn't want it? So that was my ideology, okay? I mean, this is again debatable. You can completely and fully disagree with me. I would respect that.
The Article 21 of the Constitution, it says that the liberty and freedom is protected, although subject to the laws established by procedure. Just look at Article 22, your liberty is taken away without, it can be taken away without informing you. So where do we stand? Are we for the liberty or
224. What is it for?
restricting? Restrictions.
No.
As if we are at war with somebody.
No. You have to read the Constituent Assembly debates, sir.
Your
With
speech
respect
has
to
to
this.
be stopped.
There's a reason for it. There's an absolute brilliant reason given by Shah, K.T. Shah.
That is
in the
because it
Constituent.
was made in 1950s when we had this partition and all these problems. If we were at peace when the constitution was prepared, maybe we would have gone for 21 only. You would have
So are you saying there aren't similar provisions across constitutions in the world in the right?
contradictions? No, we are the only one who has all these contradictions.
Sir, I think you should read South African Constitution. You should definitely do a reading because you're very vocal and you're really believing in what you're saying. So I think you should do a reading of the South African Constitution. I would also suggest Canadian Constitution. Yes, please. In this regard only, okay? Nothing else. Yeah, so these are the legislations. I think you can do, I think we'll get all of this if you do a simple research. So if you go through all of this, it's basically with respect to informed consent, a lot of rights are given to the individual who is having a disability with respect to informed consent, with respect to termination of pregnancy, irrespective of the fact that they are unable or able to give consent. So when you have the letter in law, when it is there, what is the issue is the question. The issue is it's in its practical application. How far have we taken away social stigma relating to disabilities? How far have we taken away social stigma relating to women in general? Then come to disabilities. So all of these aspects, I think I have conceptually covered. If you have any other questions, let me just see. Okay, I don't know what I left out. Yeah, I think I did Suchitra Srivastava. No? So I think I've covered almost everything. If you have any questions, yes.
You said about the state interest versus the women's autonomy, the two main points. So your argument was that if the state has an interest like in providing foster care, then they can argue the point from state interest, right?
Yes. With
So
respect to disability.
with respect to disabled people, right? In general, all women. So in the United States, they do have foster care. So do you support in the United States where they do have national foster care systems? Do you support their overruling of?
Absolutely not.
So
So for that you should understand there's something called standard of judicial review. So standard of judicial review means when there is a balancing of interest, such as in this case, you have the individual right on one side, on the other side you have the state interest. So a particular country will have a particular standard of review for particular kinds of laws. Let's take abortion in this case. Okay? The standard of review is where the court says that in abortion cases, the state has a huge burden. So the burden of proof is on the state to show that this legislation is absolutely necessary. Because I feel like I might overcomplicate things. Fundamental right violation case, what is it that the court is going to do? Fundamental right violation is always
Done by the state.
exactly. So it is always done by the state. That is why you have the definition of state as the first definition under part 3. You have definition of state, definition of law. The state can restrict your fundamental rights only through law, and that law should be just, fair and reasonable. That is what Maneka Gandhi said. Now how is the court going to look or balance this law and this right? So the court will say, for this law to be just, fair and reasonable, we are putting the burden of proof on the state, not on the individual who has come up before us. Generally in India, when enter a fundamental right to violate, the burden of proof is on me to show that my right is violated and the state legislation has violated my right. But with respect to abortion cases, the US court in Roe versus Wade said that the burden of proof is on the state to show that this legislation was absolutely necessary and there was no other way to bring about the object of this legislation other than by violating the individual right. So this is the concept of compelling state interest. Have you heard of that term? Compelling state interest or rigorous state interest. Rigorous state interest is a term that is used in India. So compelling state interest is where state should show this law is absolutely necessary. There reason abortion rights, it is not only with respect to the right to life of the woman alone. There are a lot of aspects relating to it. It is this is what is Roe versus Wade systemic oppression. Systemic oppression is where I talked about this, where people always politicize women's body and women's right to choose. So that was a question that was asked there, not me. Again, why is that always the case? With right to women being treated as a property in adultery. Adultery was taken out, right? It was not read down, it was decriminalized. So in almost all the laws relating to womanhood and women's bodies, instead of protecting, it is always seen as a restrictive sphere, which is why the court in Roe versus Wade said that the burden of proof is on the state. Now, when does the state interest step in. This burden of proof on the state മാറും ഒരു സമയം കഴിയുമ്പോൾ. Roe versus Wade പറഞ്ഞു ആദ്യത്തെ trimester എന്ന് വെച്ചാൽ the moment from conception till your 3rd month. Full freedom to the woman. You can do whatever you want. The burden of proof is on the state. State will decide what is, the state should show that this law is absolutely necessary. Allengi full right to the woman. Second trimester ആകുമ്പോൾ ഒരു intermediate situation ആയിരിക്കും. The state has some rights because the right to life of the fetus is stepping in. Again, like Sir was pointing out, there are a lot of scholars that say that this is a Catholic ideology, where right of the unborn, life should never be taken away, irrespective of whatever the reason, and the state should always act as a parent in protecting that right. Appo in second trimester avumbol the burden of proof on the state reduces a little. Are you able to understand? And the burden shifts to the individual a little. The individual should show that, see, എനിക്ക് abortion വേണം, ഇന്ന കാരണങ്ങൾ കൊണ്ട് എനിക്ക് abortion വേണമെന്ന് individual കാണിക്കാൻ തുടങ്ങണം. That is why in India we have a medical practitioner board after a particular period of time. They will decide whether this is required and all of that. Similar. The 3rd trimester is where the fetus is considered to be viable. That is where viability, the doctrine of viability was brought out. Viable no uddeshikkunnathu, the fetus can survive outside the womb. But because of science, now the fetus is just around, let's say, 16 weeks itself, the fetus can survive outside the womb. പക്ഷെ അന്നത്തെ കാലത്ത് fetus 3rd trimester fetus can survive outside the womb. Upper complete state interest means the entire burden is on the individual to show that I definitely need this abortion. State interest എന്ന് പറയുമ്പോൾ right to life of the fetus. State will protect. So this is how they try to balance it. ഈ balance option ഇല്ല. It is a complete ban on abortion. Balancing of rights is what is the idea or what is the innate intention of Bill of Rights. Bill of Rights is a concept, like what you call as fundamental rights. We got our fundamental rights ideology from the US, from Justice Frankfurter. Somebody from here, I'm not naming that person, one person from here traveled to the US, talked to the US.
Copied?
Not copied. Ideology was only borrowed. After we went to the US, we borrowed the ideology of negative liberty. Negative liberty is a concept where what it says with respect to Bill of Rights is that you already have these rights available to you. It is given. I mean, just because you are born or you are a human being, these are rights already with you. Part 3 of Bill of Rights is not giving you these rights. These are rights available to you. Part 3 is in place to limit state action. This is the idea of constitutionalism, limiting state action. Part 3 is there to draw boundaries on the state, to tell the state you cannot encroach on the individual rights that are already available to the individual unless and until this is satisfied. So there are conditions given. So that is the idea of negative liberty that we borrowed from the US. Whereas in South Africa, it is transformative constitutionalism, which means that the state should make sure that everybody's right is protected. There is no stepping back of the state. So unless we are equipped to be or move towards transformative constitutionalism infrastructurally, I purely believe that the right to life of the fetus with respect to mentally disabled persons, the state interest should probably take a step back. If the woman feels that she cannot, she wants abortion, yes. So basically complete, not absolute, but complete freedom. There's a difference between complete and absolute freedom. Okay? Absolute freedom is basically no restrictions. Complete freedom is you have the freedom but minimal restrictions. This is my, thank you.